This is Dr. Azadeh Khatibi, and with me today are two people I greatly admire, the wonderful lawyer Jenin Younes and the fantastic doctor and ethicist, Dr. Kheriaty. Today we're going to be talking about our AB2098 lawsuit and what's the state of it, what the rulings were, and touching on a whole host of other things, including the state of doctors' autonomy, and even looking at more long-term global issues like the threat of totalitarianism in society. So really excited for this conversation. Please, Jenin, introduce yourselves.
I'm Jenin Younes. I'm litigation counsel at the New Civil Liberties Alliance, where we mostly represent people in lawsuits against the government for violations of their constitutional rights. And I am lead counsel on Hogue versus Newsom, which is our lawsuit challenging AB 2098.
And Aaron?
I'm Aaron Kheriaty. I'm a physician in private practice in Southern California. I'm also the director of the Bioethics and American Democracy program at the Ethics and Public Policy Center. I'm one of the plaintiffs in the Hogue v. Newsom lawsuit, along with you and a few of our other colleagues in California. So I'm excited to talk about this case. It was a legal victory for us, even if it may not have come about in exactly the way that we had planned.
And I am Dr. Azadeh Khatibi. I am a board-certified physician with training in public health. I'm also a filmmaker and a freedom and free speech advocate. Also, I'm a mindfulness advocate. So let's mindfully go into this discussion, talking about what the case was about, summarizing it. Jenin, please let the audience know.
So, I believe September of 2022, Governor Newsom signed AB 2098 into law. And this was a law that essentially punished doctors for giving their patients information about COVID that departs from the contemporary scientific consensus, contrary to the standard of care. And as I believe both of of the doctors here can attest to, that's not really a standard that physicians are used to operating under. So it's sort of this convoluted sentence that, and I believe that's actually part of the purpose, but we can get into that later, sort of designed to make it so that people don't really understand this, what they're not supposed to say, what they are supposed to say. But even to the extent they may understand that, it also infringed upon doctors' free speech rights. There's no, there's no free speech exception under the First Amendment for speech that departs from the scientific consensus. So we sued with both of the doctors here and as well as the lead plaintiff, which is only for jurisdictional reasons. She's just as excellent as everybody else. Dr. Tracy Hogue and then Dr. Ram Durasetti, who's an emergency physician at Stanford. And then Pete Mazalowski, and there's so many people in this lawsuit. I think that's
No, that's it.
Yeah, that's it.
That's our 5 minutes.
So we sued Newsom and the board, the medical board, arguing that this law violated the plaintiff's First Amendment rights, free speech rights, as well as their due process rights because it was unconstitutionally vague. So when laws are, as I mentioned, have this sort of convoluted standard, that's not something that doctors are used to operating under, and they don't really know what it means. They don't know what violates the law, and so that's unconstitutional vagueness. So we made a motion for a preliminary injunction, which is sort of preliminary relief, saying that the doctor's rights, constitutional rights, are being violated, and that's essentially an emergency. We need something to be done now. We can't go through the whole process of the lawsuit and discovery and all of that. That can take years. So we asked the judge for relief. He granted it 2 days after the hearing, which is pretty unusual in a something like 60-page decision. He did not address the First Amendment issue. He reached only the due process question, and he found in our favor, so he enjoined the law. Now, we would have wanted to continue the lawsuit and gotten a final ruling, but in the meantime, the legislature repealed the law. That went into effect in January of 2024. So the law was no longer in effect, and then the government argued that the lawsuit was moot. And this is something that we saw very frequently during COVID, where the executive would issue some rule or whatever you want to call it, policy, or the state legislatures would pass laws. And then once everybody got into court, they would repeal it. So then they would argue it was moot, and the judges would often agree because judges don't want to do extra work just like everybody else. So that has sort of prevented us from getting a lot of final rulings in cases, which is a huge problem for the future, because that means if there's another pandemic and there are similar laws that are enacted or policies, regulations, a lot of these things were done by executive fiat, so they weren't even laws. We don't have precedent we can cite. Even though the judge wrote a very good opinion in our case, technically, it's not a final ruling. So he says, the plaintiffs will probably be able to show that the law violates their due process rights. But, in a preliminary injunction context, you're not saying it definitely shows that. So that's a problem. And unfortunately, the judge in our case agreed with the government that the case was moot. Probably it was the beginning of April of 2024. So he dismissed the case. We are more or less done, although not entirely, because we want to preserve our right to seek attorney's fees. Because the state shouldn't be able to get away with sort of, passing unconstitutional laws and not having to pay for it in any way. So that's ongoing litigation.
How does that actually work to make the point that we shouldn't have gone through all of this by getting attorney's fees if they've declared it moot? How do we get around that?
Well, actually, it's a very good question and a timely question, because currently the Supreme Court is considering exactly that case. So we've agreed to put the everything on ice pending the outcome of that case. So there's the case is called Lackey versus Stinney, and the question the court is addressing is if plaintiffs receive a preliminary injunction ruling in their favor, and then the government repeals the law and the case is moot, do they still get attorney's fees? So essentially, it's exactly the same question. The court just granted cert, so it's set to hear that. You know what? I'm not sure. I think they're going to hear it next term, probably. I don't think it would be this term. So we'll probably have a decision on that sometime in the fall. So we concurred with the government that it made sense to wait until that decision comes out before we continue, because it'll have a huge effect on our case. We're going to probably write an amicus brief in favor of the plaintiffs, or supporting the plaintiffs, I should say.
Yeah. I hope you guys win, because New Civil Liberties Alliance has been fantastic in pushing this case forward. So you guys deserve a lot of credit. I'm really grateful for you guys.
Thank you.
Can we talk about what happened after we got the preliminary injunctions? We were so excited to get that, and it was kind of a relief, although a lot of damage was already done by the state in chilling the speech of doctors.
One of the arguments you can make when you're trying to defeat a mootness argument is that the government, it's made in bad faith, and so the government might enact the same legislation again, similar legislation again, or try to find a workaround, effectuate the same ends through different means. So we were arguing, there were a couple of people who the board went after for so-called COVID misinformation, precisely the kind of thing that this law was designed to get at. I think a woman had told a patient that a doctor told a patient that he shouldn't get the vaccine and his girlfriend shouldn't get the vaccine if she wanted to get pregnant or something like that, and that she didn't believe masks work. So the board went after her for that. That's sort of exactly what I think this law was designed to get at. And the board didn't have a history of going after people for this type of thing in the past before the law. So we argued that that shows that this was repealed in bad faith. They didn't want to get a bad ruling in our case. They also didn't want to get a bad ruling in the Ninth Circuit. So sort of in parallel with our case, another case had been brought in a different district in California. So we were in the Eastern District. The case was brought in the Central District, and they lost. So they lost a couple of weeks before we won, different judge. And they appealed to the Ninth Circuit. Now, interestingly, the government did not appeal in our case, even though they lost. And the reason for that is quite obvious, because it's better. You want to go up on a win. You're more likely to get affirmed that way than you want to go up on a loss. So they just ignored our case, basically went up to the Ninth Circuit. They faced a very hostile panel in July of 2023. It was pretty clear. Two of the three judges were didn't think this law was any good. So then the legislature repealed it. And I think they just didn't want to create bad precedent. If they had continued to fight it, they would have gotten a bad ruling in our case and in the Ninth Circuit. So I think that was evidence of bad faith. And then you also have this woman, this physician that the board went after, at least that one. There could be more. We don't have full access to all the records because we didn't get to discovery. But so that being evidence of bad faith, we also argue, they've said this law is constitutional, which means they might just do it again. If they had acknowledged that it was unconstitutional, that would have put us in a different posture. And that was a factor weighing in our favor. Apparently for our judge, it wasn't enough.
And you mentioned it wasn't exactly the ruling we were hoping for. But there's also some silver linings to it. also, I mean, what are your thoughts on the mootness
Sure.
ruling and what it actually just means for physicians? You've been such a vocal advocate and someone who's spoken out when other people have been, other doctors have been afraid to. Like, how do you look at this, where things stand, what the mootness ruling
Yeah.
says?
Well, I think it's a win if we can communicate to a sufficient number of physicians that we actually won, not in court, but by getting the law to be repealed by the legislature, who saw the writing on the wall and saw that they were going to lose in court. So that establishes a sort of playbook. If they tried again in another state. This law was something that I think was being road tested in California with plans to try to roll out similar laws elsewhere. So there's something called the Federation of State Medical Boards, which is a professional medical boards in various states responsible for licensing physicians in various states. And this Federation of State Medical Boards actually published a document on so-called medical misinformation where they advocated passing laws like this. So there was a national sort of template for doing this. And I think California, there's some advocates in California and some activists in California picked up on that and said, let's try to do that here. And the fact that it didn't work here and that at least so far it hasn't been tried elsewhere suggests to me that, if they try this again, they're going to take a very different approach that, will attempt not to run afoul of the First Amendment. So I think very clearly they probably didn't expect that some doctors in the state would push back. Most doctors were cowed into silence. Most doctors didn't stand up against this sort of thing because they're afraid of being punished. They're afraid of losing their license. So it took a handful of us, I think, to go into court and say, no, this is wrong. This violates our constitutional rights. And even aside from that, this constitutes really bad medicine because scientific truth is not established by consensus. Consensus has absolutely nothing to do with the truth or falsity of a scientific claim. Scientific claims are established on the basis of evidence, and the degree to which we adhere to them or, we put sort of firm faith in them has to do with our assessment of the level of evidence in support of them and the level of evidence that might undermine them. And that actually has virtually nothing to do with consensus. So trying to build a framework of understanding science and medicine in a rapidly evolving area like the treatment of COVID, trying to build that around consensus is just building a house on sand. Unfortunately, I think a lot of physicians have sort of forgotten that, and they've been cowed into silence by a law like this. And so it's very important, first of all, for them to understand that this law has been legislatively repealed. Second of all, that it's been repealed in large part because doctors in the state stood up and said, no, you can't do this, and we're going to get this law struck down because it is constitutional. If you want to leave it on the books. And so they decided not to leave it on the books, and the legislature and the government pulled back on it. That's a win. The downside to all of this is this pattern of catch me if you can, where our leaders have decided, and I think this is an old story, but it seems to be increasingly common, I would say, over the last 5 to 10 years, that executive and legislative actors will basically do things that they know the courts are going to strike down, but the courts grind slowly. They're not designed to react immediately next week, to a bad law that the state legislature passes or to an unconstitutional move that a governor or a president might make. The wheels of justice in the courts do grind, but they grind very slowly. So this tactic that I call catch me if you can is sort of like, we're going to do something that we know is probably unconstitutional, and we're going to get away with it for as long as we can, and we're only going to stop when they sort of make us stop, right? Which is exactly what happened here. I think it's a bad faith form of governance. I think it shows a total lack of regard for the rule of law and for the constitutional order. It shows, obviously a lack of respect for citizens, and it's a form of an abuse of power. So I do hope the Supreme Court gives us a ruling whereby people who do this can pay some sort of penalty for it, at the very least. I mean, I would think paying the lawyer's fees for someone who challenges that kind of move would be a bare minimum form of getting your hand slapped for engaging in egregiously unconstitutional behavior. So I don't have a big picture solution to that problem, except that, we still have to continue using the courts when and where that's necessary to challenge laws like this. And the courts also don't work automatically. So this is a reminder that courts can only work based on cases, and cases are brought forward by people who are harmed by laws. And so I think this is a good example of some physicians recognizing we're being harmed by these laws, and we stand to be harmed in the future by these laws. And we're not the only ones who are going to be harmed, but representing other doctors in the state, we're going to step forward and try to do something about it. I like to tell people, if we don't stand up and defend it, the Constitution is merely a piece of paper located in the National Archives in Washington, D.C. If it's going to be anything more than words on a piece of paper, it requires that American citizens exercise their civil and constitutional rights and defend those constitutional rights when they come under challenge. And in individual cases of being harmed by a law or a regulation like this, that means taking your case to court. So I'm proud to have been a part of this effort that forced lawmakers to walk back this law. I think if they try it again, we'll go after them again. And maybe if they try it again, then the mootness argument won't work next time around. But I think I think it's up to citizens just to kind of be diligent, be dogged, and I'm grateful for NCLA too, because citizens don't have the resources to take something like this to court. Maybe if it's their own livelihood is immediately threatened and at stake, they're going to mortgage their house. They're going to sell. They're going to put up whatever resources they have to try to defend their own livelihoods. But when it comes to just striking down a law because it compromises the practice of medicine, we need generous people supporting organizations like NCLA to allow us to step forward and do this, because going to court is a resource heavy proposition. It's very expensive. And so private citizens acting on their own accord will typically find a hard time doing that unless they have benefactors and organizations like NCLA to help them out.
Oh, thank you. I didn't tell you to say
that. They didn't pay me to say that. I just, no, I'm thinking about, it's like, oh yeah, just take them to court and sue them. Well, even for physicians who, are generally pretty well-established professionals that, have learned to navigate the world and know how to get things done, the idea of defending their rights in court seems very, very foreign. Most doctors are terrified of lawyers. We stay as far away from them as possible. A courtrum is the last place we want to find ourselves.
For sure.
Right? With the association is malpractice and some patient going after and trying to sue me. So I think it took a really special group of doctors in this case to kind of get together and say, hey, no, we're not going to put up with this.
Definitely.
And I think, thinking about the idea of the special group of doctors, I thought I was so alone until I started kind of participating more with different organizations and going to rallies, or just Aaron and I met at a talk where he was speaking. It's just, and then creating that interconnected web. And I think if you're like a doctor working from morning till night, doing your thing, like it's going to be hard to create those networks and meet people.
Yeah.
And so you just constantly, and then, you're chilling your speech at work too. Most doctors aren't independent anymore as well. That's a problem because they can lose their job if they speak out. And so it's hard for them to even have the network and feel that sense of support so they do speak out. I think that so many of us, majority, not all, but so many of us have gone through like college, medical school, residency, fellowship maybe even, and then practice where you're, trying to pay back your loans for most people. It's like you don't even know other ways and other routes to take to be able to advocate for yourself. It's like such a big deal to do that. I was kind of scared to even get involved because I was so worried that someone was going to come after me, right?
Yeah.
Someone, big brother.
Sure.
But at the same time, I was just like, I have to act. And if there's one message that I want to make sure our viewers, our listeners get today is that when you take that step to advocate for yourself, you start meeting people that are like-minded. You may get some, resistance and even hate as well, but which I got, and I'm sure you've gotten, Aaron. I know you guys have had.
Oh, I only get fan mail.
Yeah.
All day, every day. Just people who love everything I'm doing. It's great.
But you're doing such important work that you believe in. But, that resistance can also be very scary to a doctor who likes security. Most of us, our personalities are that we like security. We like to know what's going to happen next and when. And so the idea of like bringing a lawsuit is very daunting, I think, to most people. So I hope that another thing that was accomplished by doing this lawsuit is to teach other doctors and to model for them and for just other citizens that this is possible and that you can do it. And once I did it, it was such a freeing feeling. And I realized, I can figure out the legal system. I have a lawyer, wonderful lawyers who can like help me navigate it and know what to do. And step by step, you can fight the government.
Yeah, and I see a lot of doctors who are fed up with the system and they're bailing out. And I understand why. Doctors are retiring early. They're leaving practice. There was a recent AMA poll that I saw that was like 20% of physicians plan on leaving medicine in the next couple of years, and like 2/3 of them plan on reducing their hours. So this is a very serious crisis of personnel in medicine. And while I sympathize with people who want to leave medical practice because they're fed up with it, another part of me wants to say, I think of that old movie back from the 1970s called Network, where this guy stuck his head out the window and just started screaming, "I'm mad as hell and I'm not going to take it anymore." And it sort of like caught on. All these other people started sticking their heads out of their apartment windows.
He did it on the news. He did it on the news.
Yeah, that's right. It was on the news. And then it became this thing. And so I think it's time for doctors, before you just sort of bail out and, go take up, golf or horticulture or something like that, to stand up and say, no, I'm mad as hell and I'm not going to take it anymore. Patients are being harmed by this. I'm here to serve patients. I'm not an agent of the state. I'm not going to operate with a gag order. I mean, what patient can possibly trust a physician who has a gag order and is reading from a script written by the California Department of Public Health? This is nonsense. This is crazy, and I'm not going to do it anymore. So, I don't know how we organize in that regard. I think efforts like this can maybe hopefully embolden physicians to say, before I just sort of walk because I'm close enough to retirement that I can manage, or, I can find some other way to make a living in the meantime. Just think about, okay, maybe I need to stay and fight for a few years. Maybe I need to stay and organize and start pushing back against these trends that are undermining the ability of doctors to actually care for patients and turning medicine into this kind of machinery of control, which always seems to be the state's. Yeah, I mean, that's the state's interest in medicine, right? As far as I could tell now, the highest value in medicine is placed on efficiency. Efficiency toward what end is never asked, right? It's just like do more for the sake of doing. And I think patients very often feel like they're funneled through a system designed just to move people through the system, like turnstile medicine. Like you go to Disneyland, and it's people moving, right? It's you move through lines, you wait in lines, you go through the turnstile, you get processed, you kind of, and at the end of the day, supposedly you had fun. Well, medicine is kind of operating that way now. The care is not individualized. You're made to do things that have actually very little to do with your chief complaint. You're asked all kinds of questions that have very little to do with, what you're actually presenting with. Physicians have become glorified data entry clerks rather than doctors caring for, individualized patients with very particular ailments. Physicians are fed up with it, but, we also have the power if we organize to. We're the only ones, I think, at the end of the day that have the power to organize and try to do something about it.
Yeah.
Can we talk a little bit about why the law is different? So this was a question I got a lot, and I think it would benefit from not just a lawyer answering it, but why is this different from what physicians are used to operating under? Like, you have to abide by some kind of standard of care, right? That was the question I got. Like, well, I mean, if you tell your patients to drink bleach, that's presumably would be a problem. How does this law differ from that kind of thing?
Standard of care is actually not a medical concept. It's a legal concept. It's a minimum threshold to establish whether or not there's been a breach that may constitute a form of malpractice. If there's a breach, the standard of care, and there's harm to a particular patient, then there may be a case that the patient has against the physician for malpractice. But the standard of care is not a set of fixed propositions that are written by the AMA or the American Psychiatric Association or another medical society about this is the way that you always treat patients with fill in the blank, COVID or heart
Right.
disease or cancer. Physicians have always been able to exercise a lot of discretionary latitude in terms of tailoring particular medical judgments, particular patients, taking broad recommendations from public health agencies or from medical societies and applying them to individualized cases, which are always more complicated than some abstract, generic patient.
So the government would respond. They did respond to that by saying, well, that's exactly what we're doing here. We're not creating a new standard. We're just saying, if in the situation where you were so against the consensus,
Yeah.
like drinking bleach or whatever, something like that.
Well, if that's the case, then the law is redundant. And clearly,
Right.
if the law was just redundant, they wouldn't have passed it. And they passed it with the additional language that we've mentioned already of
Right.
current scientific consensus, which is not a legal concept. It's
Right.
not even necessarily a medical concept. I mean, it's on any particular scientific or medical question, it's not always clear what the current consensus is. The current
Right.
consensus is most often, well, there's some evidence for this and there's some evidence for that, and the evidence is mixed, and there's disagreement among competent physicians and people of goodwill about, whether it's best to use this chemotherapeutic agent for this cancer or that chemotherapeutic regimen for the same cancer. So by trying to fixate in law this notion of current scientific consensus, essentially what that does is just confuse physicians, right?
Right.
Because is there a consensus? If so, how do I find out what that is, especially when the evidence is changing week in and week out with new studies being published all the time? And, is my own read of scientific literature ahead of the curve? In which case, if you polled a bunch of doctors to figure out supposedly what the phantom idea of the consensus is, maybe I wouldn't necessarily align with what most people think or with what most people think they know, but maybe that's because I actually know the research literature better than they do.
Right.
And, my
That's,
only
I think,
crime is being 9 months ahead of the curve.
read that like the average doctor takes 17 years it takes 17 years
To
before the
catch up.
latest studies.
Yeah.
Like,
Or like it takes 17 years before
Before-
a new
yeah,
becomes commonplace in
Yeah.
medicine.
that's
it gets
right. That's what I was. Yeah.
the rate of adoption is going to be different in like a cutting edge academic center that's actually doing the research about it versus,
That's right.
some small populated clinic that's operating, at low capacity. It may not even be on their radar,
Right.
and they may not even offer to their patients. And I think that's another important point that kind of goes back to the question of standard of care. Actually, legally, even standard of care is going to apply differently to different populations of doctors working in different areas. So what one group may be held to a standard of care in a busy metropolitan area, those doctors may be held to a different standard legally than some doctor operating somewhere else who doesn't have those resources. So their standard of care may be different. So the same thing with consensus. That's also kind of
Yeah.
not a legal word, but it's also kind of, you don't really know how that's defined because is it formal consensus? Is it informal consensus? Is it just kind of the general opinion? Is it has to be something published formally by a group of doctors coming together and putting
Right.
out a formal consensus paper? Like these things are all confusing. And so what also happens, in addition to the things that Dr. Kheriaty mentioned, is that it's not just the doctor's confused, it's the doctor can become afraid. They
Right.
can say, I don't want to be wrong. I don't want to be singled out. And so they just don't
That's
say anything.
that's the chilling effect, which is, I mean, it's a serious concern in First Amendment law. And you look at
Yeah.
that as if the law is so vague, or even, if the law can be interpreted in a way that would chill protected speech, then that's an issue. And
And
I
if
think, I mean, another component of this, which we brought up, was the consensus is often wrong, and progress is made in science and medicine by people sort of following their instincts and being ahead of the pack. And like Dr. Duracetti said that during COVID, at the very beginning, they were saying you should intubate everybody with serious illness. He actually, he's one of the best physicians. He was probably had a better gut feeling than most of them, and something told him that was the wrong approach, so he stopped intubating patients, and his did better. And then that became the, standard of care or whatever however you want to put it. So if you hamstring people by saying you're going to be punished if you, follow your instincts, then that creates massive
That's right.
problems, I think, for advancement.
And the whole history of medicine is replete with these examples. I mean, late 19th century, I'm going to forget the doctor's name, but an obstetrician who basically ran the experiment himself and showed that his outcomes were better in terms of infections following deliveries if he washed his hands before, he assisted a woman giving birth. The medical profession.
Semmelweis. Was it Semmelweis? I'm
Semmelweis,
sure
yeah.
Semmelweis.
They drummed him out of the profession. I mean, this guy's crazy. That's the most superstitious, stupid. What would hand washing have to do with, what happens with inflammation in the birth canal? I mean, the germ theory of the disease was not yet, so they didn't have an underlying mechanism to explain it, but he had the data. I don't know how to explain it, but when I wash my hands, I get better outcomes. So you can drum me out of the profession. You can call me crazy if you want. But of course, now the scientific consensus has caught up. There was another case like this in the 1970s, early 1980s of the guy who basically first proposed the hypothesis that gastric ulcers were caused by a bacterial infection, by H. pylori, which is a bacteria that can be found in the gut. And therefore, to treat gastric ulcers, we need to give antibiotics. And again, people thought, no, this is crazy. Everyone knows that gastric ulcers are caused by stress. And by the way, the two hypotheses were not mutually exclusive because stress can lower our immune defenses, which can make you more prone to get H. pylori and so forth. Antibiotics for ulcers, this is quackery. This is, but of course, the guy ended up winning the Nobel Prize in medicine after having established that this is in fact the case. And, he was disinvited from all the medical societies. They really punished him. And
I heard of someone named Galileo too, I think.
Yeah, it's an old story in science, right? That science advances by challenging what everyone takes to be the case, what quote unquote common sense tells us. Everyone can see that the earth is not moving and the sun moves across the sky. So why are you proposing this backwards theory? And the joke in science very often is that science advances one funeral at a time.
Yeah.
Because there's this social element within science of, if I've endorsed a hypothesis or a theory throughout my career and sort of staked my reputation on that, then this up and coming person who's challenging that, I and my cronies are going to work to box them out by, through the peer review process or through the, kind of leadership in the medical society process and so forth. So consensus building can be a dangerous proposition in science and medicine. These power dynamics create what our friend Jay Bhattacharya calls the illusion of consensus, right? You get censorship. You get a law like Assembly Bill 2098 that has a chilling effect on free speech of physicians. And then you get the false appearance that medical doctors all think the same about fill in the blanks, lockdowns, school closures, COVID vaccines for children, whatever. Whereas, in fact, there's no such consensus. There's simply exercise of raw power at the level of the state government, the federal government, the state medical board, the medical journals basically are punishing any dissidents. And when you start punishing dissidents, you have no mechanism built in for correcting course. If you're wrong, if you start down a pathway that turns out to do more harm than good, in a healthy, functioning medical and scientific system that allows for open debate and free speech, there are mechanisms in place to be able to correct mistakes, hopefully before too much damage is done. But if you hamstring those mechanisms of correction through censorship, through government-enforced propaganda, then you have no way of getting off a train that's heading for disaster. You have no way of, correcting course if you started down a path that's actually proving to be more harmful than helpful.
Yeah, and I think that's why this case is helpful to underscore that. One of the things that I want to make sure that our listeners really realize is that there was something very important with this case, and that part of our work in doing this was that we put pressure on the government made them at least get the preliminary injunction and maybe realize we did something wrong. And then the governor of California, Gavin Newsom, went up to my friend after the law was repealed, and he went up to him. He's like, it was my idea. It was my idea to do the repeal. And it never should have passed in the first place, this law. And I'm thinking to myself after I heard that, I was like, dude, why'd you sign it in the first place? You know? So I want to make sure that the people who are listening understand and really feel that there was some great things that came out of our fight, in that we got the law repealed, we put pressure on the government, they realized they were looking bad optics wise.
Getting a preliminary injunction is a big deal. They're not granted very often, certainly not like for a facial challenge to a law. So I mean, this wasn't, this was saying the entire law is unconstitutional. Was not an as-applied challenge where something's already happened. So it is unusual, and although it doesn't technically have precedential value, I mean, people read the decisions. It's a well-written and thought-out decision, 60 pages. It will serve a purpose down the road. Like, I cite stuff like that for persuasive appeal, even if it's not technically binding on courts. So I don't think we should downplay the significance of obtaining the injunction.
Thank you.